CNBC-TV18.
Well, hello and welcome to Newscentre. I'm Ashmit Kumar. The Bar Council of India has allowed for foreign law firms and lawyers to practice international law and arbitration matters in the country in India. Now, the permission, however, will be on the basis of reciprocity. The Bar Council says that opening up will be regulated to ensure that it is mutually beneficial for lawyers for India as well as lawyers looking at India as a potential market. In fact, to take this discussion forward, I'm now joined by Satvik Varma. He's a senior advocate, as well as Mr. Suhail Nathani, a managing partner at Economic Laws Practice. Gentlemen, thank you so much for joining us. Mr. Varma, let me come to you first. You've studied law in Harvard. You're admitted to practice in New York. You've worked in Wall Street. You were also a partner at Undivided Amarchand. So you tick all the boxes as far as areas that can get impacted by the notification of these rules. Tell us your first takeaway as far as foreign lawyers being allowed here are concerned. Is it an opportunity, or will it prove to be a challenge to the existing firms and lawyers practicing in India?
Thanks, Ashmit. It's always a delight to be back on your shows. So thank you for having me today as well. It's definitely not going to be a challenge for Indian law firms. I think Indian law firms are extremely creative, and they are in many ways ahead of the curve, and they know how to innovate fairly efficiently and in a time-bound, smart manner. So I don't think it's going to pose any challenge whatsoever. It's a welcome move. I think we need to consider a couple of things. It's a move that's come very close on the heels of the visit of the President of the Law Society of England and Wales. It's something that's happened right after the Delhi Arbitration Week, which was a celebrated event held in Delhi where the Chief Justice of India spoke. Also close on the heels of the ABA event which took place. So clearly India and the Indian legal market has been a focus. The devil lies in the detail. I think the Bar Council still needs to work out a lot of the details as it stipulates in the regulations. And I think we should all wait, or it'll be wise for us to wait for those before we can really move forward. But a definite good move for business in India, good move for the development of the legal industry in India. And the fact that the Bar Council has promulgated these rules is also indicative of the fact that the big lobby that was preventing this entry from happening has now been comforted, which was largely the litigation folks. So I think all in all, a positive step forward, and we will need to wait and see before we deliver a verdict on this.
Well, also joining us is Mr. Nathani. Mr. Nathani, thank you so much for joining us. Again, the same question to you. In 2018 is when we had the Apex Court partly allowing foreign lawyers. Since then, it's taken 5 years for the BCI to come out with these rules, the Bar Council to come out with these rules. Your first take on that, is this a challenge, or is this an opportunity? I asked that question because the areas which the foreign lawyers and law firms are being allowed into, which is mergers, acquisitions, this for very many law firms is their bread and butter. So I asked that question, challenge or opportunity?
Well, any change in status quo is an opportunity. Is the opportunity without challenges? I don't believe it is without challenges. It will bring its own challenges. And while I agree that Indian law firms are able to and will indeed step up to the plate, there is also this whole situation of having restrictions placed on Indian law firms for several years. So, for example, websites, what kind of advertisement, if any, all those things have been under strict control of the Bar Council of India. And while I appreciate that foreign law firms operating in India have to adhere to the Bar Council rules, the fact is that all of them are overseas based, and the rules in those countries are fundamentally different to what we are operating under over here. So yes, an opportunity, but not without challenges.
Mr. Varma, let me take that across to you. When we talk of whether it's an opportunity or challenge, let's first talk about the interest there. Given your international experience, what can you tell us in terms of your interactions with foreign lawyers and law firms? Is that energy, excitement there to look at India as a potential market? The Bar Council talks of potential FDI, developing India into an international arbitration hub. Do you see that interest overseas to be a part of this India story?
The short answer is yes. I think there clearly is an interest, and the interest has been around. I graduated from my master's in America 20 years ago, and I can tell you from experience then that almost every big law firm has had an India practice desk, and that number has only grown. The hub for some has moved from the United States now to Asia, Singapore, Hong Kong. London has always been a bit of a melting pot where there's been a lot of people and a lot of big firms with their India teams. So yes, there's a huge amount of interest and there's a huge amount of focus towards this. Right now, keeping that in mind, what we also need to consider, Ashmit, is what the rules allow. At some level, and when I first read these, I read the rules a couple of times over. Not much has changed in a practical sense, in my mind, or to my mind. And the reason I say that is the only thing that seems like a marked difference is the fact that post the Supreme Court judgment in BCI Balaji, where they were not even allowed to do non-litigious stuff, these regulations allow that, right? But as the conditions have been stipulated, it has to be on a reciprocal basis, which is number one. It has to be on matters that are not connected with Indian law, so foreign law. There are restrictions and stipulations on who these services can be rendered to. And the end user of those services, in most cases, also has to be a foreign party, which is another restriction. And it also clarifies to say that, look, if you are, Satvik Varma working at a law firm in England and you file your returns in England and you're registered in India, you still can't practice on the Indian law aspect. So in that sense, not much has changed. But yes, I think it is going to be, it definitely brings about a change where these firms will be looking to move into India and set up shop. At least some of the big ones will be. And we've already seen press reports of some of the big firms reporting, stating their interest.
Right. Well, speaking of setting up shop, Mr. Nathani, let me talk to you about the detail as a part of these rules there. A lot of compliance is required on part of foreign lawyers or law firms looking to enter the Indian market. In fact, just for registration, I believe there's a long list of about 11 documents that have to be submitted for being allowed to participate in this India story. The question I'm asking is, are these important guardrails that are required to ensure that the space remains firmly regulated? Or will it serve perhaps as another case of red tape that may come in the way of genuine interest as a part of the India story?
So, we can't start off looking at something that as though it's going to be red tape or an impediment. We assume these are going to be guardrails, but we have to look at how other markets that liberalized and who had similar rules eventually shaped up. See, it's very important if these are intended to be guardrails, they operate as such. The fact of the matter is that there is a lot of detail that remains to be A, interpreted and B, implemented. So if you have those clarified or implemented in one case, you will know what is going on. So the point I would like to make is that there are two fundamental changes, okay? One is that the foreign law firms can come here and do arbitrations as long as one of them, their clients, has an office outside of India. So it doesn't matter whether it's under Indian law or foreign law, they can come here and do arbitrations. Arguably, they were doing that in any case. The second situation is that there is no bar on advising on transactional matters. Okay, and the regulation is very clear that it says they shall be allowed to practice on transactional work, corporate work, such as joint ventures, mergers, acquisitions, intellectual property matters, drafting of contracts, and other related matters on a reciprocal basis. So this gives them opening into the Indian legal market. And I believe that, it is going to be a very interesting opportunity for many of them who will be knocking at our doors for a very long time. But it is going to be subject to how the Bar Council is able to regulate them, because in some of the markets they have operated, these guardrails have not been that effective because you structure around them.
Sure. We're running out of time, Mr. Varma. Let me come to you for a final word. As Mr. Nathani was pointing out, there's a distinction that the rules make that as far as foreign lawyers, law firms are concerned, will only be allowed as far as transactional issues are concerned. So mergers, acquisitions, contract, drafting of contracts, that's a space where they're allowed, not litigation. Let me ask you a question about looking ahead, perhaps at the future. At what stage can we begin to consider that question of even allowing foreign lawyers and law firms into litigation, seeing a foreign lawyer compete against one of the senior advocates, competing, arguing against you in the top court of the country? When do we see that debate?
Well, if left to me, never. But look, I think we have to look at this from a evolutionary process, right? It is going to be good. As Suhail pointed out, any change comes with its own challenges. Let's take, for example, and I know we're running out of time, so I'm going to keep it brief, but live streaming. A lot of people have said live streaming is not going to be the best thing because it's going to restrict the bonhomie enjoyed between the bar and the bench. Contrastingly, the arguments yesterday held before the constitutional bench relating to the Maharashtra Assembly are so beautiful that at lunch, all of my colleagues and I were looking at it and learning from it. So I think that it's a similar change. I think we're going to be, we're still far removed from litigation opening up. Just to give you a perspective, Delhi saw 14,000 registration of lawyers last year and has over 128,000 lawyers registered on its rolls as of date, a large majority of which are in litigation. So that's not a space that the Bar Council, according to me, is going to allow, and perhaps for good and right reason, to open the doors on. There's still a lot of detail. I think Suhail mentioned we need to see what happens. I also think there's a lot that needs to be formulated. For example, there's incongruity between the definition of international commercial arbitration under the Arbitration Act and as it's defined under these regulations. So even in these arbitrations, presumably applying principles of law, they'll only be able to advise on the foreign law aspects, again, to that end user. So I think as a first measure and, just letting the ink dry up on this, I think it's a great way forward. It's a great step forward. It's a great move. A lot of it is going to get, the creases are going to get ironed out in good time. And we should welcome it with open arms and not with fear. Trepidation is okay, but not with fear for sure, as if it's going to uproot us.
Right, Mr. Varma. Right, Mr. Varma. I'd like to thank both of our panelists, Mr. Varma as well as Mr. Nathani, for joining us and sharing their insights on this subject. But with that, we're slipping into a very short break. But coming up on the other side, U.S. has confirmed former Los Angeles Mayor Eric Garcetti as the country's ambassador to India. A discussion with Professor Haresh Pant and former diplomat Anil Trigunath when we return.